any flexibility.
I think that's what we did last time. We allocated time, but we were flexible enough to add time whenever it became necessary. So with those submissions in mind, I will give you the time allocations which we have given, but with the latitude to grant more should it be necessary.
My Lord, I was going to request that because we are prosecuting these applications, that we just say that officially so that you don't think I don't feel pressure that 30 days. This is a kind of case, my Lord, that if you do not argue it, inevitably this case will somehow have that. I don't want anybody to accuse me. I did not argue this or the other when I had an opportunity. 30 minutes will not bring heavens down. It is only 15 minutes to enable me to do the job, not for myself.
My Lord, here we go again.
Let me speak. This is a court of law. I respect you very much, counsel, senior counsel, and all the counsel here. But please let us appreciate that this is a court of law. And when directions are made, please let's respect those directions. I'm making this direction. We have allocated time. Should it become necessary for one party to ask for more time, we will consider that. Thank you.
My Lord, the first application in which we have filed these documents in the file officially called Petition number E015 of 2024 is an application dated 21st of October 2024. It is supported by an affidavit that has been sworn by this affidavit has been sworn by the Honorable David Ngunyi Mabenge. It is further supported by a supplementary affidavit that is 21st of a supplementary affidavit of 24th of October 2024 by the Honorable David Mabenge. My Lord, in addition to that, we have filed a bundle of authorities which I believe that they have been furnished to the court. My Lord, looking at my watch, it is 3 p.m. I am certainly going to require some additional time, but let me start and see how best we can manage the time that has been allocated. Well, in the ruling that you delivered yesterday, you made a significant point that this is a matter of extreme public importance that deals with the most weighty issue that can be conducted, both with regard to the office that it relates to and to the issue of political succession. My Lord, the issue of political succession countrywide is an existential issue of the state. Existential issue of the state in the sense that this is an issue that when you read Professor Namwebe, Ben Nabweze, and when you read all these cases from Pakistan, they are the most weighty constitutional issues that can appear before any group of judges. And my Lord, for purposes of this country, we are saying that for the 2010 constitution, the matter before you, and that is why has informed the filing of this application, is one that is an existential issue for purposes of the 2010 constitution. Your Lordships, I say...
Your Honor, sorry for interruption. You have been muted. I am unable to follow proceedings. Okay. Now it's okay.
My thought process is affected now. Yes, my lord. So I was submitting and saying that it is an existential issue for two reasons, my lord. My lord, most of us who are at least practicing for 20 years are aware of two provisions from the former constitutions of Kenya. We used to have a section 23 of the Kenyan constitutions, in which all executive powers were vested in the president. That position radically changed under the 2010 constitution. We used to have section 30 of the constitution, in which parliament meant the president and the legislature. My lord, those positions changed. The change of those positions, which is the submissions that we are making, the impeachment proceedings would have the consequences, if it goes the way in which it has gone, of effectively bringing back to life sections 23 and sections 30 of the former constitution. Now, the second issue that I need to emphasize on the existential issues of the constitution is this. My lord, from the standpoint of the constitution and to safeguard constitutionalism, there is these issues that is called security of tenure that certain offices enjoy, particularly with regards to the questions of removal. My lord, the two offices that enjoys the greatest tenure are the office of the president and the office of the deputy president. My lord, why is that the case? Because they are legally protected that to remove a president or a deputy president, you need impeachment. They are also secured by the electoral process, that those two people, to get to those offices, they must be voted into those offices by the people. But the significance of this is this. Every other holder of the offices, from constitutional office holders to judges and everybody else, doesn't enjoy political tenure. It is only legal protection for those particular offices. So that, my lord, the point is this, that the true weight of this matter is this. If it were to turn out that an office that enjoys the greatest protection, like the office of the deputy president, can be called, the removal can happen as we are alleging it happened in this case. My lord, the whole scheme of constitutional tenure and protection that is necessary to protect our democracy would effectively be null and void. This would mean if you have numbers, you do not like the speaker of the day, you can get him out. Numbers in a democracy, and that is why you write the constitutions, numbers must be controlled by law. If we reach a position where numbers cease to be controlled by the law, my lord, that would effectively have negated all the constitutional gains that this country has gained. My lord, having made that point of the nature of the issues that you are dealing with, let me come to the issues before you. My lord, the petitioners, or in those cases, in those affidavits, in the applications, are saying a fairly simple issue. They are saying that as a result of events that occurred in Kirinyaga, that are partly the subject of the yesterday's decision that was made, and as a result of other matters that is the subject of the supplementary affidavit, the petitioners feel, and the petitioners are of the strong opinion, that a case of this magnitude is not the kind of case that should be decided by a bench in which they do not enjoy full confidence in. My lord, the basis of that, since this is highlighting, would be four. My lord, on the first issue is that the petitioners, and in their applications that they did and is a subject of overruling, they pointed out certain issues that brought into question the issues of the transparency, the proper accountability for purposes of the handling of that particular file. The affidavit is there. And then according to the petitioner, that brought into them some doubts, the manner in which the handling was done as to the impartiality of this particular bench. The petitioners goes on to issues number 2. They say that whereas they put in an affidavit setting out the reasons why there was a problem in the manner in which those issues were done, the respondents did not respond to challenge those particular set of facts. But my lords, the petitioners are saying that now that the respondents did not challenge their set of facts, the contrary issue that happened is this, that in the ruling that was read yesterday, we got a copy 30 minutes ago, there was a section that was called other issues. In the section that was called other issues, the petitioners are saying that this court answered factual and evidential issues that relates to that application. And the consequences of that is that although they had been agreed, to them that would amount to this court entering the arena of conflict between the parties, the petitioners and the respondents. And my lord, the old principle applies that a judge, one cannot be a judge of his own cause, and in any matter that they are dealing with, it should be a matter that they are absolutely neutral as far as the facts and the evidence are concerned. My lord, in our African societies, I talked to my parents, I talked to Mr. Oganda, he said his community had the same set of issues. According to my community that I came from, in any those cases that used to be done traditionally, the first thing that would arise was this, and Article 159 says we respect our customs. It was to ask those who will be able to determine this case, are all the parties satisfied with this group of wazes that will be deciding the case? If either of the parties say,
the community does not do that.
I don't know about yours. I say mine. I don't know. Mine is. I don't know. Oganda will talk for himself. But let me have some peace. I think he wants to destroy my train of thoughts. But the point I was saying, I can be happy. Oganda can defend himself what he told you. But what I'm saying, at least for my community, that issue arises. Does any of you have a problem with any of these wazes who will decide the issue? My lord, if the issue arose that a party says, we don't want that mzee to be there or that other one, invariably, and this is communal justice, that person would pull out and get a mzee, another mzee that everybody feels comfortable with. So that, my lord, and I've appeared with you, I respect all of you absolutely. The petitioners are saying the circumstances of this matter is that we are unable to enjoy that confidence. My lord, when the petitioners were speaking about what they said they feel, like is a 3-judge bench, one in which they expect fair and square justice. That was a terminology in the case of Gerongori that we have attached on our submissions. That from the word go, a party appearing before the judges should be able to feel that we have a reasonable chances of success between those judges, but more importantly, that none of the judges is connected to the cause, one to the cause or to the individual in which you are in dispute with. My lord, why is that important? That, my lord, is important because since Saturday of this week, in fact up to yesterday, but the petitioner says they have been treated to a situation, and a lot of those information people have sent it to my phone because they have seen me on television. Where we have such a scenario that repeatedly they keep saying we are going to have what is it swear? We are going to have a swearing in as soon as these 3 judges give those particular orders. But that cannot create confidence, because assuming it is not this case, every party, and we have very many cases here, if somebody, you are drinking in a bar, says, no, you are going to lose that case before the persons we are appearing before. That, my lord, is a party. Parties are not lawyers, are not supposed to be sophisticated. That party will be left certainly with a huge problem as to whether actual justice is possible. And it might actually be, my lord, that whenever else is dealt, the petitioners will win this case. As we expect, we shall win if the petition is heard. My lord, if that is the case, and that may actually be the case before you, but my lord, the scenario that is bad and that is prevented by the law is a scenario where the parties lose. Because they will say, well, you have Abenasi told us, Oscar Subi told us, Kabet told us, and all these individuals who are saying it was called drama. We are here for entertainment. But if judges are supposed to be treated to entertainment, and those judges are supposed to stop that entertainment, but there is a problem on the face of it. There is a notice of appeal that we have filed, and it is part of the supplementary affidavit. In this notice of appeal, your lordship, we have pointed the issue, and we have said one of the other issues of concern is that the judgment of this court that dealt with these other issues, that judgment, the contents of that, amounted to preempting and answering the application that I'm arguing before the court. Because those issues we are submitting did not come from the respondents, but these applications having been filed, we are arguing these applications. After, in a previous ruling of yesterday, we have effectively been responded by the court itself. The petitioner says that they are absolutely uncomfortable with that, and they cannot be able to say that if we have reached a situation whereby judges are answering our case in advance, it is absolutely bad and beyond repair. But the second last issue that I want to say is this. The issues, my lord, is, and we expressed that concern yesterday, we were not sure whether we would even file a notice of appeal as counsel. But you are told you cannot file this one because it is the issue, as far as we are concerned, we were not treated fairly. We were accused, we are playing to the gallery, as a result of the accusations and indictment that we are playing to the gallery. What effectively ended up being glossed over is the question of